Good afternoon, everybody. It's my pleasure and honor to welcome you to the University of Wisconsin Law School for our annual Thomas Fairchild Lecture. It is a delightful spring day, as all of you know, made even more delightful by the fact that the judge was able to join us for this afternoon's festivities, for which we are all very grateful. It's made even more delightful by the fact that this year's Fairchild Lecturer is one of his former clerks. I suspect, since we include in the program always the list of former clerks, this might not be the last time because it's a very distinguished bunch, but at least Judge Raji will initiate that tradition. Judge Reena Raji was recently appointed to the United States Court of Appeals for the Second Circuit after serving roughly 5 years as a district judge in the Eastern District. What? 15. It shows you my math, you know, and I'm about to grade a whole bunch of exams, so it's a good thing I get some math practice here. That's right, 15 years. Thank you, Judge. As the district judge in the Eastern District of New York. She received her bachelor's degree from Wellesley College, where she was Phi Beta Kappa, and was a cum laude graduate of the Harvard University Law School. But you know, I think there's always sort of a funny tradition about this. All of our lecture attendees are very smart people who can read the English language, so there's something always kind of odd about me standing here and hitting the highlights from the printed text that you could read for yourself. So I will add something that doesn't show up there that Bill Conley was kind enough to share with me, and that is that among Judge Raji's many contributions, one is unlisted here, and that is it was principally her idea to do this series of lectures and organize the clerks. So we are tremendously in your debt for that, Judge Raji. So without any further ado, let me introduce Judge Reena Raji.
Thank you. It was a beautiful day in the fall of 1988 when I visited the campus of the University of Wisconsin Law School to hear Justice John Paul Stevens deliver the first Fairchild Lecture. And I will unhesitatingly state that it was a thrilling experience to witness a pretty good idea being transformed into a great reality. As you know from your program, the lecture series was conceived not just by me, but by Judge Fairchild's law clerks out of our enormous respect and deep affection for a great jurist. Now, this is a group of clerks that over the years has had a lot of bright ideas. For example, some of us used to think it amusing to sign into the Federal Building in Chicago under assumed names. Names like John Marshall and Felix Frankfurter. But fortunately, the statute of limitations on those pranks has run, and our best idea, the Fairchild Lecture, endures. I have to confess that on that fall day in 1988, my vision was not so far-reaching, or perhaps I should say so bold, as to ever imagine that I would one day be standing at this podium delivering a Fairchild Lecture. The shoes into which I step are large indeed. In addition to Supreme Court justices, Fairchild Lecturers have been Wisconsin Supreme Court justices, great legal scholars, lions of the bar. Among this illustrious group, I am most undeserving of the honor of this moment. But among the group, I doubt if anyone has appreciated it more. And so to the task at hand. For the last 7 months, I have served on the United States Court of Appeals for the Second Circuit, undoubtedly a great court, but about whose work this rookie is hardly in a position to comment. On the other hand, for the previous 15 years, I served on another great court, the United States District Court for the Eastern District of New York, and there I witnessed firsthand the great contribution made by trial judges to the administration of justice in our nation. It is about the role of the district courts that I wish to speak today. Now, the district courts hardly arrived on the national scene with much fanfare or applause. When the framers met in Philadelphia in 1787, there was general agreement that the United States needed a national court, but memories were still scarred by abuses of the royal courts in the years leading to the Revolution, so the states were hardly eager to empower a web of national courts. Indeed, as Perry Miller, the great historian of that era, has observed, 18th and early 19th century Americans were generally ambivalent about the law, lawyers, and courts. Men like John Adams and Joseph Story may have been inspired by reading Blackstone, Grotius, and Pufendorf, but many of their fellow Americans viewed the law more suspiciously, almost like a foreign language spoken and understood by an elite who thereby sought to distinguish themselves from average hard-working folk. Hardly an image consistent with the emerging democratic vision. Jefferson expressed this ambivalence when he criticized American lawyers for succumbing to the honeyed Mansfieldism of Blackstone, whom he viewed as essentially undemocratic. And he never thought much of judges. He thought their power should be narrowly circumscribed so that a judge operated as a mere machine with no discretion to depart from legislative directives of the people. But I'm getting ahead of myself. My point is that among the miraculous compromises worked in Philadelphia that sultry summer of 1787, the framers conjured up the federal judiciary in words notable for both their majesty and their vagueness. Article 3, Section 1 states simply, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." In that almost offhand reference to inferior courts were conceived our present 94 district courts, on which serve almost 1,000 judges, counting, of course, the jewels of the system, our senior judges. While I'm in Section 1, let me observe that it does have another sentence for which federal judges have always been indebted to the framers. With an equal economy of words, those remarkable draftsmen ensured judicial independence through the dual provisions of lifetime appointments and undiminished compensation. The net result, as one of my colleagues' law clerks aptly observed, is that Article 3 means never having to say you're sorry. Whatever misgivings some 18th century Americans may have had about a federal judiciary, the first Congress did create district courts. Appointments were hardly coveted. It is reported that President Washington had to cajole and coerce, often in vain, to get people to serve on the federal bench. And it was not until 1803 that a district judge could preside alone over a trial. As you may recall from history, federal trials in diversity cases were initially conducted before a panel that included Supreme Court justices sitting together with district judges. But the burdens of 18th century travel proved more daunting than the justices were prepared to bear. And so, it was simple practicality as much as conscious jurisprudential restructuring that bestowed on district courts their great power within our judicial system, the power to shape cases and bring them to trial. My purpose today is not so much to chronicle the history of the district courts as to highlight the ways in which the exercise of their power contributes to the administration of justice. Now, toward that end, it may be useful to start by recalling the particular place district courts occupy in our system of government. From its creation, our republic has consciously, some might say obsessively, been concerned with separating, checking, and balancing power as the means to guarantee liberty. The framers pursued these means in part because they were avid students of political theory and heirs to the Enlightenment. but also because they were shrewd judges of human nature, simultaneously confident of man's ability to govern himself, but cautious of his potential for selfishness. And so they decided that no person, no branch of government would be entrusted with unchecked power, for the inevitable result would be tyranny. And so we have inherited this marvelously complex system where the power of governance is in the first instance shared between the nation and the states, and then within the federal government itself, there is the famous separation of powers among executive, legislative, and judicial branches. I might digress here for a moment to note that although these branches are almost always described as co-equal, it is interesting that the adjective independent has been applied almost exclusively to the judiciary. From Hamilton's famous discussion in Federalist 78 to yesterday's Law Day proclamation by the President, everyone extols an independent judiciary. People do not speak about the importance of an independent Congress or an independent executive, although no one doubts the enormous power these branches wield within their appointed spheres. As for me, I have to wonder how independent a group the judiciary really is, given that everyone in it dresses alike. While you think about that, let me return to my main point. After dividing power between the states and federal government and dividing it further among the branches of the federal government, our polity then divides it yet again, at least within the judiciary, among the three levels of courts. Now, consider the net effect of all this separation, division, and checking. It means that every participant in government, district courts included, is assigned only a discrete share of power. At the same time, however, each participant is expected to exercise its assigned power fully, not only in order to carry out its particular duties within government, but because this is the means necessary to check abuse of powers by others. Now, these are delicate balances, and the lines are not always bright, which has on occasion given rise to moments of high drama in our nation's history. But if we put the district courts into this dynamic context, we can better understand the importance of their role. For while the power they exercise, like all government power, is necessarily circumscribed within their assigned sphere, district courts have the opportunity and indeed the duty to play a robust role in order to ensure the true administration of justice. 15 years on the district bench convinced me that there is much to praise in the work of our federal district courts. Now, to the extent I use examples to make some of my points today, I will necessarily draw from what is familiar to me, the work of the Eastern District of New York. For those of you unfamiliar with that district, the legislation creating it was signed by President Lincoln a few weeks before his death. Carved out of the Southern District of New York, the Eastern District presently encompasses the three New York City boroughs of Brooklyn, Queens, and Staten Island, and the suburban counties of Long Island. It is home to New York's two major airports, its 5 organized crime families, and the Brooklyn Museum of Art, all of which tend to generate a regular stream of criminal and civil litigation for the district court. While the Eastern District has a special place in my heart, I refer to it today only to illustrate the exceptional work done across the nation by hundreds of judges serving on those 94 federal district courts. If Holmes was right, that the life of the law is not logic but experience, then nowhere is the law more regularly reinvigorated by experience than in the rough and tumble world of the district courts. Pick a year, any year, and look at the docket of a federal district court. In an instant, you will be able to grasp the myriad factors, social, political, and economic, that are generating and animating disputes within a community. From the flood of criminal cases generated by Prohibition in the 20s, to the flood stemming from the wars on drugs and terrorism in our own times, from intellectual property disputes that try to keep pace with 21st century technology, to a host of civil rights challenges, from mass tort litigation by thousands of victims to the review of a single person's denial of Social Security benefits. These legal battles are all waged in the first instance in the district courts. Now, what is the significance of that fact? I think there are several points worth noting. First and most obviously, the district court plays a powerful role in shaping the factual record in a particular dispute. Its power in supervising discovery, ruling on preliminary motions, establishing procedures through pretrial orders, admitting or excluding evidence, is considerable. While some of these rulings may be subject to appeal, not all are, and in any event, rarely right away. Indeed, in cases that settle, and that is most cases, many district court rulings may never be reviewed. In criminal cases, the power is particularly great. As a district court judge, acting alone, I could sign my name on an order, and before night fell, federal agents might be wiretapping your telephone or barging through your front door, and there would not be much you could do about it. Indeed, in the case of a wiretap, you would probably not even know about the intrusion for several months. By contrast, as a circuit judge, about the only thing I can do on my own signature is grant a party leave to file an oversized brief. District judges are acutely mindful of their power to shape litigation, whether on the civil or criminal side of the docket. And in my experience, they exercise this power with considerable self-discipline and a careful regard for fairness. Charles Wyzanski, who was, of course, a legendary federal trial judge, discussed the responsibility that went with this power in a 1952 Harvard Law Review article. He observed that a district judge striving to exercise power responsibly faced 4 challenges: to be critical of one's own shortcomings, attentive to the reaction of the bar, informed of the unrecorded practices of his colleagues, and above all, reflective of the subtle differences in the tasks assigned to him. Now, how candid any human being can be about personal shortcomings is, of course, a difficult question, and it takes experience as well as careful thought to recognize those subtle differences among assigned tasks. But certainly, district court judges can, and for the most part do, pay attention to the concerns of the bar. In the Eastern District, judges strove to agree on uniform practice rules to avoid burdening the bar with a host of individual rules. Moreover, these rules and all court practices were developed through advisory committees on which individuals served from all segments of the local bar. Similarly, because the Eastern District is a court renowned throughout its circuit for collegiality, the judges were well aware of each other's practices and indeed regularly sought counsel and advice from one another. So let me turn now to the second noteworthy point about the role of district courts. With their power to shape cases come opportunities for considerable creative experimentation. In the Eastern District, no one was more willing to experiment than my former colleague, Jack Weinstein. Joseph McLaughlin, formerly the dean of Brooklyn Law School and another Eastern District and now Second Circuit colleague, once said of Jack Weinstein, he never met an innovation he didn't like. One area where Jack Weinstein's imagination has particularly contributed to the administration of justice is the field of mass tort litigation, particularly his handling of claims of Vietnam veterans exposed to Agent Orange. Now, there were some 600 Agent Orange cases assigned to Judge Weinstein involving multiple state and national laws applicable to 2.4 million potential claimants. If these cases were not to languish on a court docket in some modern-day version of Jarndyce versus Jarndyce, creativity was plainly required, and Judge Weinstein supplied it. As Professor Peter Schuck wrote, Judge Weinstein seemingly waved a magic wand and simply vaporized the formidable choice of law problem that was creating a logjam in the cases. Judge Weinstein declared that any state court presented with one of these cases would undoubtedly look to identify a national consensus on the law regarding manufacturer liability, and to that extent, his federal court must do the same. Now, Judge Weinstein is a serious legal scholar, and as Professor Martha Minow has observed, the magic he worked depended in no small degree on his tour de force analysis of the choice of law options available to him. But contributing to the magic was also a large dose of district court practicality. You see, Judge Weinstein shrewdly insulated his ruling from any attempt at interlocutory review by declaring that his choice of law decision was not so much a ruling as a provisional announcement meant to guide the parties as they moved their case forward to trial. His goal was plain: keep everyone in those 600 cases before the court, get them moving, and maintain maximum legal flexibility should any actually go to trial. In fact, on the eve of trial, Judge Weinstein hammered out a settlement. There were appeals, and most of his rulings were affirmed. But my point is that many of his actions, including his critical provisional announcement about choice of law, went unreviewed. I reference this to illustrate the considerable power district courts have to take enormously complex, challenging litigation and shape it with a view toward resolution. I might also note that when, as a district judge, you have a colleague like Jack Weinstein, it doesn't really matter whether you agree with him or not. To share a bench with someone of his intellect and energy is to have one's own standards of excellence raised. A few years ago, though, one of my Eastern District colleagues called me to get my opinion on a ruling she was thinking of making, and I was urging a bit of caution, expressing concern that the action might not survive appeal, to which my colleague said, "Well, I think it's what Jack Weinstein would do. Don't you think I can get away with it?" I thought about it for a moment, and I responded, "Sure, just make sure you sign his name to it." Before I move on, let me suggest that one of the reasons our system of limited government allows and even encourages a measure of district court experimentation in shaping and handling cases is that more often than not, there is the availability of appellate review to check any serious deviations from accepted law. District courts, for all their independence and power, are not intellectually autonomous. Indeed, no judge in the system is. As Archibald Cox once observed, the rule of law requires fidelity to the past, applying a continuity of inherited legal principles at the same time it strives to meet the dominant needs of the times. Of course, district courts themselves follow this principle, but they lack the safety in numbers available in appellate courts to ensure that established principles are not stretched to the point of distortion. Now, I didn't always see it that clearly when I was a district judge. Not that I didn't hold the Court of Appeals in the highest regard. In fact, like many of my district court colleagues, I viewed appellate judges with a proper degree of awe, as if they were akin to the gods on Mount Olympus, distant and remote from those of us mere mortals who daily slogged it out in the trial arena. And like the gods, appellate judges would watch from on high as the participants in a trial battled, and then, only when it was over, would they swoop down from the hills and kill off all the survivors. Now that I sit on a court of appeals, I've tempered that view a little. Well, we've now discussed the district court's ability to shape cases and to apply creativity to the process. What else distinguishes the district court's exercise of its judicial power? Certainly, the humanity that district courts can ensure for our judicial system. In the appellate courts, the law is necessarily about abstract legal principles, but in the district courts, it is still possible to appreciate how the law concerns and affects flesh and blood human beings. After all, the persons affected by the cases heard are frequently standing in front of you in court. This is obviously so in criminal cases, where a district court will gain considerable insight into the defendant, into members of his family, the victims of a crime, and sometimes their families. There are no adequate words with which I can convey to you how affecting it was for me in a racketeering case involving an Asian street gang to hear from a young woman recently arrived in New York from Ireland about having her husband die in her arms because they had the misfortune to be eating in a Chinatown restaurant on the night when members of the gang sprayed the place with bullets in retaliation for the owner's failure to meet an extortion demand. You simply had to be there. Similarly impossible to convey is the genuine remorse evident in some defendants compared to the token acceptances of responsibility by others. District courts do their best to fit the highly individual circumstances they confront into normative standards, for instance, like the sentencing guidelines. But the task is not always easy. It was Cardozo who wisely observed in a different context that the springs of human conduct are subtle and infinitely varied, and we depend on district courts' perception, sensitivity, and common sense in distinguishing human conduct so as to serve justice. Whether a case is criminal or civil, it is the respect that district courts show the individuals before them that perhaps speaks loudest about our society's commitment to justice. And this is particularly apparent in the case of pro se litigants, who in the Eastern District now make up about 1/5 of the plaintiffs in civil cases. As every district court knows, some of these pro se cases are filed by troubled individuals. Others involve claims that, even when read liberally, only state that life is unfair, which may be true, but for which there is no federal cause of action. Still, I can honestly say that I do not regret one moment of the time I spent over 15 years listening to pro se litigants explain why they felt themselves aggrieved, or explaining to many of those litigants why I had to dismiss their cases. Most of them were just grateful for the respectful hearing, even if in the end the court could not give them the relief they sought. Sometimes, though, it was possible to redirect pro se claims to an agency or department that could afford relief, and in this respect, the district courts are often assisted by the civil divisions of the United States Attorney's Office. If for me there was a single case, though, that emphasized to me the human face of justice as administered at the district court level, it was one I had involving a pro se litigant who actually had a colorable claim under ERISA. Because I knew the plaintiff would not be able to navigate ERISA by himself, I persuaded one of the city's large firms to take the case. It assigned 2 very bright young associates to the matter, and they did a terrific job representing the gentleman at a bench trial. In the end, however, I had to conclude that his claim lacked merit, and so rule for the defense. The following week, I received a remarkable letter from the plaintiff, briefly expressing his disappointment at the outcome of his case, but then profusely thanking me for the serious consideration given his claim. Even more affecting, though, was a conversation that I had some months later with one of the young associates who represented him. He told me that the plaintiff had insisted on giving the lawyers something to show his appreciation for his efforts. Being a man of no means, the only thing he could give them were some records from the classical collection he had lovingly built up over his lifetime. And the young lawyers did not have the heart to tell him that neither of them owned a turntable. It's a tale that O. Henry might have written. Now, my remarks thus far have focused primarily on the district court's interaction with litigants, lawyers, and the appellate courts. But district court power extends to another group of persons about whom I must say a few words. For indeed, it is a group essential to our system of justice with which only the district court deals. I speak, of course, of the jury. Selecting a jury is, to my mind, one of the most interesting and challenging tasks a district court performs. While it is permissible for a district judge with consent to refer the selection of a jury to a magistrate, I generally did not do this. I wanted to know who the people were who would be sitting in my courtroom hearing a particular case. One can learn an enormous amount about one's own community selecting a jury. In the Eastern District, which is still an immigrant district, I was constantly amazed by the rich diversity of our juries and constantly impressed by how people from so many different backgrounds and with such different outlooks could come together and apply themselves so conscientiously to a difficult task. Now, lest you think I have stars in my eyes with respect to juries, let me assure you that I spent many a Monday morning staring out at a courtroom of people not very happy to have received jury notices. But it was my job, and that of every other person working in the district court, to help those jurors understand how essential they were to our system of justice. And here, too, the critical factor was respect. I was one of those trial judges who did little things like make everybody stand up whenever the jury went in and out. I like to think gestures like that can sometimes help juries think more highly about themselves and the trial process. But it's equally important to respect other aspects of jury work, for instance, their time. I could tolerate a lawyer wasting my time, but not that of a jury. It's important to respect juror privacy. It's really extraordinary when you think about it. The jurors are plucked out of their daily routine and thrown into a trial, sometimes a high-profile one, and asked all sorts of personal questions about themselves in open courtrooms. Now, obviously, the parties have a right to explore potential juror bias, but it takes district judge wisdom to distinguish between necessary information and prying. Most important, I think, is that when the trial is over, jurors be allowed, in the words of learned hand, to melt anonymously back into the community from which they came, without fear that they will be haunted or harassed because of the service they have performed. Finally, district courts must respect the intelligence of jurors. I devoted a lot of time and effort to translating difficult statutory language and layer upon layer of judicial gloss into instructions comprehensible to a lay person. This is not always easy. Try explaining the vertical and horizontal relationship requirements of a pattern of racketeering. But it can be done. And indeed, it's facilitated enormously when judges give juries instructions in writing as well as orally. Although there are many challenges in selecting and instructing jurors, there is enormous satisfaction in seeing the transformation. For however sullen potential jurors are when they report for jury selection, the vast majority of persons who do in fact serve leave our federal courthouses with a profound sense of satisfaction and a renewed faith in our judicial system. And for that, we owe a large debt to the district courts. On this point, as on so many others, de Tocqueville had it right. When in praising the role of juries in a free society, he noted that by obliging men to turn their attention to other affairs than their own, it rubs off that private selfishness which is the rust of society. Just as jury service helps to rub the rust off a free society, so the work of district courts ensures against any rusting in our judicial system, forced to confront the most challenging questions of a dynamic and changing society, empowered to shape disputes to ensure a full development of the record and a just resolution of claims, constantly confronting the individuals whose lives will be affected by the law. Our federal district courts have not simply rubbed justice free of rust, they have burnished it to a high sheen. Thank you.
The judge has kindly agreed to take questions, but I think she's already earned her prize here, which she, as a member of the audience, you know what this guy is, I hope.
do.
It's the symbol of the law school. It's the gargoyle. He's also available for aerobic whatever, as you can tell by his heft.
This is
so
true.
we will mail it back to you, so you don't have
thank
to,
you.
unless you would prefer to,
No, thank you.
try to get him through airline security. Somebody is going to, I think, help me with the mic. Somebody from Extension.
Someone comes forward.
Oh, wait, no, wait.
They're making their way.
So if you've got questions for the judge, and we'll just sort of pass the mic around so the questions get picked up on the tape. Thanks, Judge.
Thank you.
I wonder if you'd care to comment on the effect on district courts' independence of legislation such as U.S. sentencing guidelines and more particularly the recent Amber Alert legislation and its effect on judges' ability to depart from the guidelines.
If I'm correct, the recent legislation was narrowed from what it originally was. If, just in case anyone's not familiar with this, the Senate and House were considering legislation that would have limited the ability to depart from the sentencing guidelines to factors that had been identified specifically by the Sentencing Commission. And you could not come up with anything that you thought perhaps had not been identified by the Commission. As I understand it also, there was originally some discussion about reporting to Congress district judges who departed over government objection. Did that survive the legislation in the Amber?
I think it did.
Yeah.
It's really that part
All right.
that I'm
And what I understand is now this will only apply in these sex crimes, but the question is this like a first right, and that now what will happen is every time anyone wants to show that they're very serious about some area of criminal law, this will be one way of demonstrating that. Well, first let me start with the guidelines. The guidelines, like so much legislation, started with such good ideas and such hopeful purposes to try to bring uniformity and not have people feel that if they committed bank robbery and were in front of judge, harshness, they would get one sentence, and judge lenient, they would get another. But of course, it's always difficult to fit round pegs into square holes, and that's the problem. I mean, initially, I think most of the Court of Appeals thought that the guidelines should be read pretty strictly, and after a while, especially when the Supreme Court gave the green light in Kuhn, the Courts of Appeals were much more flexible in giving district court discretions, which I generally think is a good thing. But how much this is now going to change the landscape, I don't know. I think the notion of reporting judges to Congress if they depart over the objections of the U.S. Attorney is something people want to think about, because practically the U.S. Attorney's Office may often object to a departure but not really care whether you depart. Institutionally, they may have to take a particular position, but they do not have strong feelings about it. If that starts to get magnified, I think it'll create distortions that might be unfortunate. Yeah.
Are there residency requirements for appointment as district judge and Court of Appeals? And if so, what are they?
Oh, well, I think for most districts, you do have to reside in the district to serve as a judge there, and in the circuit, you have to reside within whatever states are your circuit. There are, though, exceptions for the New York metropolitan area, the D.C. metropolitan area. I don't know if there are others, so that you can live within a radius, and that's because, for instance, the Eastern District of New York, where I was, I could walk to the Southern District of New York. I could just walk across the Brooklyn Bridge, but for many years, judges could not live in Manhattan, so they've been more flexible about that.
Not sure I need this. Comment, if you will, on Rule 56 as a way of lightening your caseload. Was it used? Is it used? And if you'd comment on 56.
On summary judgment motions, I mean? Well, summary judgment motions are made all the time by parties. But as far as whether how much district courts use them, I mean, you know, if there's any factual question, you have to let it go to trial. There were many, many cases where I thought that it was not likely, in my opinion, that a plaintiff would succeed. On the other hand, it was a factual question, so I had no choice but to deny summary judgment and let it go forward. Sometimes I would talk settlement with parties like that and see what, you know, where it was, whether there was some other disposition than trial, but some cases can only be resolved at trial. Thank you all very much.